Thank you so much, Love, and thank you all so much to everyone who is here tonight. I know that the evenings are busy times for families. You are making dinner and being with your families, and so the fact that you were here spending your time with us is a big honor, and I hope to honor that time by making this as informative and useful as possible for you. I also wanted to thank Pizzi and Love and Tina for all of their help in coordinating this series. We are so excited about it. Again, this is a 5-part series that we are doing. We had the first session 2 weeks ago when Amy Walters from our office did an introduction to the school to prison pipeline and the juvenile legal system. This is part 2, where we're going to go over school discipline hearings. And then in 2 weeks, Teresa Hepler and Ashley Moore in our office are going to be presenting on school-based arrest. And there's 2 additional parts after that. So again, it's a great series. I hope you'll be able to join for the rest of them as well. And also wanted to thank Brittany Harry, who is a fabulous intern in our office, and she has been a big help this summer and a big help in putting this presentation together. So I'm so excited that she could join as well. I wanted to apologize for the sun. It's coming in from my eyes, so I'm bobbing and weaving, trying to avoid it. I'm also hoping that my family and my cats don't sort of appear beside me as we're giving this presentation, but it's possible that you might see some stragglers as I am in my home. So again, it's so nice to be here with you all. Thank you so much for sharing your time with us, and I will turn it over to Brittany.
Thank you, Cassie. And just to piggyback off of Cassie, I'm honored to be here tonight to also present this presentation on school discipline with Cassie. But just before we get started, we wanted to recognize that this may be a difficult topic for parents who have experienced different levels of school discipline. So we would like for any parent who is comfortable sharing, and no pressure, the opportunity to be heard. So if you would like to share your experience with school discipline, please message me privately in the chat. And as the presentation progresses, there will be a segment where we will share 1 to 2 stories anonymously. So this presentation will just provide a little bit more insight to school discipline as it pertains to suspensions and expulsions in Virginia. And just before I turn it back over to Cassie, I wanted to highlight some notable data regarding school discipline. So over 73,000 students received more than 127,800 out of school suspensions in Virginia in the 2016 to 2017 school year alone. And that amounts to 586,280 school days and education time lost. There is a higher suspension rate for African-American students and more specifically for African-American males with disabilities. And I think that's on the next slide, Cassie. Yes. So just again, just some alarming facts that higher suspension rates are amongst African-American students and more specifically amongst African-American males with disabilities. And as you just reflect on some of the data that I've presented, I will turn it back over to Cassie so she can provide a little bit more context as to that. So I'll turn it back over to you, Cassie. Thank you.
Sorry, was unmuting the remote problem. So thank you so much, Brittany, for presenting that data to us. During the presentation that we had a couple weeks ago, Amy Walters also presented a lot of information on the school to prison pipeline and the racial disproportionality that exists among school discipline, in particular in school-based arrest. And so I think it's an important way for us to set that context for an understanding of how some of that happens. And so we hope to provide some of that context tonight, and also some information that will be helpful for parents and advocates in navigating this process. And so I want to start, there's lots of information that we'll present tonight, but I wanted to start by setting the stage for what school discipline is. What do we mean when we talk about suspensions and expulsions? What are some things that a student can be suspended or expelled for? And then we'll get into more the due process rights of students in that process, and then some information about special rights of students with IEPs during school discipline matters. And so again, if you've got questions, we're going to get to those later, but please ask them throughout, put them in the chat, and we will make sure that we save time for those at the end of the presentation. So a student can be suspended or expelled from attendance at school for sufficient cause. And so that's, a student gets in trouble at school for a variety of different things. And then the principal or the administrator decides that that student needs to be removed from school for a couple of days. They have to have some sort of good reason for doing so. But that's really vague, and there's a lot of different rules about what behaviors can lead to suspensions, and then how many days and what a punishment could look like based on what those actions are. So your school division's code of conduct has a lot of information on what those suspensions are and what that has to look like. And so I really recommend looking at your school division's code of conduct to find more specifics about what students can be suspended for and what those suspensions look like, how long for certain offenses or actions. Also wanted to ground us in some definitions. And so different rights trigger based on whether something is a short-term suspension or a long-term suspension that we'll talk about later in the presentation. And so a short-term suspension is a suspension from school that is 10 days or less. So if something is 9 days, 10 days, it's a short-term suspension. Long-term suspension is 11 to 45 days. And so an expulsion is 365 calendar days. So again, just kind of keeping those different ones in mind. You'll also notice throughout the presentation that I put in code sites. So I put citations to the law where all of these exist. I think it's really important that parents and caregivers be empowered with knowledge about the law, because school divisions are certainly aware of this, and it's important that parents are also aware of where to find these things so that you can know about the law and present it and be ready to advocate in these situations. And so I'm not going to read them all out, but they're there in case you need them. And we will make sure that Love and Pizzi have this presentation so that they can get this out to everyone afterwards if you are interested. I'm also going to be looking down some at my notes, and so forgive me as I'm sort of looking up and down. So let me see. Let's move to the next slide. Okay, so just some exceptions. So a student cannot be suspended for truancy alone. So if a student is not going to school, then they can't be suspended or expelled for not going to school. There's a specific process that a school has to go through in order to address truancy. It's not suspension and expulsion. And so if you are interested in finding out more about that process, there's some resources at the end of this presentation from our website. You can find a link to the resources on our website. In particular, the Helping You Help Your Child manual has some more information about truancy, so you can find out more there. But it's too much to do in the short time that we have today. Students can also not be charged with disorderly conduct anymore at school. This is a recent law that passed 2 years ago. Students can no longer be charged with disorderly conduct, which was a big win for students because we were seeing that quite a bit in Virginia. Also, a student who is a child who's in preschool through 3rd grade cannot be suspended for more than 3 school days and cannot be expelled unless one of these circumstances are met. And so one of these things, either physical harm, possession of a firearm, possession of drugs, or aggravating circumstances, which of course is very broad. And we are finding that school divisions are using this aggravating circumstances to suspend younger kiddos for more than 3 school days. And so, but really there needs to be one of these exceptions met now under the law for a school division to suspend or expel a younger child, a preschooler through 3rd grader, for more than 3 days. So some of the most common actions that we hear about that lead to suspensions or expulsions are possession of cell phones, minor insubordination or disrespect, classroom disruption, and using inappropriate language. And so you can see that of the three of the last ones, there's a lot of subjectivity, there's a lot of vagueness. For example, what I might consider disrespectful or inappropriate might be different from what another person might consider disrespectful or inappropriate. And so what we do at the Legal Aid Justice Center is we advocate for codes of conduct to be really narrow and specific so that staff, students, and parents all know exactly what actions lead to particular suspensions or punishments. And so we want to be really specific about what does disruption mean? What does disrespect mean? Because that leads to a lot of subjectivity and bias, and it lends more to the disproportionality that we see that Brittany mentioned and also that Amy mentioned in the presentation from a couple weeks ago. So we want to be really careful about using these really vague terms in codes of conduct. So another question that I get a lot from parents is, when can my child be suspended or expelled for something that they do not on school grounds? So for example, not something that they do in the school building or on the school campus, but something that they did at home or in their community, not at all related to school. So generally, schools cannot suspend or expel students for off-grounds behavior, even if it results in juvenile charges. There is an exception for serious offenses. Students can be suspended for up to 10 days for certain offenses if the offense involved an intentional injury to a student at the same school. I also want to note that there is some reporting that happens between law enforcement and school superintendents. So if a student does something in the community and then is charged with a particular offense, a particular crime, then that student, the law enforcement agency does have a duty to, sometimes in certain cases, to report that to the local school superintendent. And so there is some mutual reporting that happens back and forth. And in the presentation in a couple of weeks on school-based arrest, there's going to be some more information about that, but just wanted to flag it now. Also, another thing I wanted to mention here, sorry. One of the questions that we get sometimes is, when can my student, and this is something we hear all the time from parents who have teenagers in particular, is social media. What can my kids say on social media? Can they be in trouble? Can they get in trouble for that? And so actually, this is something that recently the Supreme Court made a decision on. And so actually on June 23rd this summer, so very recently, the court considered this very issue and handed down a decision that was actually quite friendly to students and not so much to schools. So in this case, there was a student who tried out for the cheerleading team and she didn't make it. And so being very upset, she posted to her personal Snapchat some very disparaging remarks about the school and about her teammates and about the school administrators and various things, quite angry, quite disparaging. And so she was suspended for that. And ultimately, the Supreme Court ruled that yes, a school division can discipline a student for something that they say. So this is a speech, this is a First Amendment case, for something that they say on social media, but it's got to be something that really substantially disrupts the school programs. So it's got to be a pretty high bar. And the Supreme Court ultimately said that this wasn't enough. This wasn't a big enough disruption. And so I want parents to come away with this not thinking that students can say anything and never be suspended for something they say on social media, but know that it is a pretty high bar. And students do have First Amendment rights that they carry with them in this process. That's really important. So I wanted to make sure you knew about that too. So now moving to due process. So that kind of lays the stage, lays the groundwork for what discipline in school looks like and kind of the background. Now I want to get into due process for all students, kind of what rights do students and parents carry through this process, and what rights are you making sure are protected as a participant in this process? So a principal must tell a child why they are proposing to discipline the student and also give the child an opportunity to tell his or her side. So for example, say a student gets in trouble, maybe they yelled in the hallway or something, and that student is then called to the principal's office. The principal must say, okay, I think I'm going to suspend you for one day. And you need to explain to me why you did that. That has to happen in order for the principal to be able to expel that child. Parents are then entitled to notice of the incident. So they have to know what happened. They have to know the proposed disciplinary action. So in this case, that the child's going to be suspended for 1 day, and also their right of appeal. So there's a right to appeal both short and long-term suspensions, but there's some differences there, and we'll talk about those. But there's a right of appeal that attaches. Also wanted to note that incidents at school can form the basis for juvenile court petitions, and any written statements given in this process can be used in a juvenile court proceeding. So it's important to be careful with written statements. So for example, say that student, let's use another example, say a student tipped a desk over, and on that desk was an expensive computer that the school owned. And say the principal is suspending the child for 15 days for that. But also the school resource officer wants to charge that child with property damage based on the fact that they damaged this expensive computer at the school. If that child were to give a statement to the school administrator about how, yes, they tipped this desk over that then damaged the computer, the SRO can then take that and use it to file a juvenile court petition. And so it's important that parents and students be aware before making written statements that those can be used in juvenile court petitions. Also wanted to note that when we say due process, we don't mean the opportunity to cross-examine witnesses, and also there's no right to representation in this process. So you certainly can have an attorney in this process, but the school's not going to give you one automatically. There's no right to that, and there's no right to cross-examine witnesses in these hearings necessarily. So it's a little limited. So I mentioned notice. So notice requirements attach for both short and long-term suspensions. So this is the notice that has to be given to parents whenever a school is proposing to suspend a child or expel a child. And notice has to include the length of the suspension, so how long it is, information concerning the availability of community-based educational, alternative, or intervention programs. So basically, what opportunities are there for a child to continue to receive educational services while that student is being suspended? And also the right to return to regular school attendance after the suspension ends. And so the notice has to include all of those things. However, there are some particular rights. So that talks about due process rights. So we've got notice, we've got appeal. We have several different rights that attach for all students when they are facing a school discipline action. There are particular special rights that attach in addition to those for students who have IEPs in particular. So when I say IEPs, I mean individualized education programs that students have because they have a disability. So how a school disciplines a child depends on whether or not the child has an IEP. So for example, if you have 2 children in school, both of whom have ADHD, but only one has an IEP, the process for disciplining each student is going to be different based on which one has an IEP. So I wanted to give an example here to kind of better illustrate this issue. And so I'll be talking about this example throughout the next several slides just to further illuminate this complicated process here. So Cameron is a 5th grader at Virginia Elementary. He's a student, and he has been sent to the principal's office for disrupting class. So let's imagine that this was a pretty significant disruption. He maybe turned over several computers, turned over several chairs and desks, and maybe he shouted, several things. It was a significant disruption, took him a while to get him calmed down and sent to the administrator's office. So pretty significant disruption. And Cameron has been diagnosed with ADHD and he has an IEP. So now let's say John. John, who is another student, is also a 5th grader, also has been sent to the principal's office for disrupting class. Also a significant disruption, turned over things, was yelling. John also has ADHD, but he does not have an IEP. And there could be several reasons why John doesn't have an IEP for his ADHD and Cameron does. Maybe John's is well managed with medication. And so neither the school nor his parent ever the school isn't seeing any issues really. And his parent maybe never told the school that he has this diagnosis. He's through the special education identification process, and the school determined that even though he has a medical diagnosis, he doesn't meet the special education requirements as a child with a disability for ADHD. So there could be lots of reasons why John doesn't have an IEP and Cameron does. But for the purposes of this example, John doesn't have an IEP, but Cameron does, even though they both have ADHD. So in this situation, how Cameron and John are going to be treated is going to be different depending on the type of suspension that they get. So for students who are going to receive a short-term suspension, so that's a removal for less than 10 days. So say that Cameron and John both get to the principal's office and the principal's like, I'm going to suspend you both for 5 days. So it's a short-term suspension. All that Cameron and John are entitled to are the due process protections that we've already talked about. Notice, a hearing, right to appeal. They're entitled to all of that, but nothing special happens to Cameron for a short-term suspension just because he has an IEP. However, let's say the principal tells both Cameron and John, I'm going to suspend you both for 13 days. That now is a long-term suspension, and schools must, so different things are going to happen to Cameron and John because this is now a long-term suspension. And so for John, because John doesn't have an IEP, he is not going to, he is only entitled to the due process protections that we already talked about. Cameron is entitled to all of those. He's entitled to notice and a hearing. Also, Cameron is going to be entitled to something called a manifestation determination review hearing, and Cameron is going to be entitled to services during removal. So because Cameron has an IEP, he has these special protections, and we're going to talk about what those things look like. So the manifestation determination review hearing. So I'm going to spend a lot of time on this slide. So if I miss anything or go too fast, please feel free to put questions in the chat for me to clarify anything later. So a manifestation determination review hearing, sometimes referred to as an MDR hearing, is a meeting with the school to determine whether or not an incident is a manifestation of a disability. So let's talk about Cameron. So Cameron has ADHD and he disrupted the class. And the principal is saying that he wants to suspend him for 13 days. And so Cameron is now getting this MDR hearing. And at the MDR hearing, the school is going to look at, was Cameron's disruption of the class caused by his disability? Was it caused by his ADHD? Was his disruption of class directly and substantially related to his ADHD? And then there's another inquiry too. There's another question that the school has to ask. And that is, was Cameron's disruption of class the direct result of the school's failure to implement Cameron's IEP? So in this case, for example, let's think about maybe Cameron is supposed to have a one-to-one. And that one-to-one aide, so that's a person who sits with him all the time at school. Maybe that person helps him focus, helps him calm down when she sees him getting upset. And maybe that person couldn't be there that day, and the school did not find anyone else to replace that person. And that is when this incident happened. I would say that's an argument that is the school's that this disruption of class was the direct result of the school's failure to implement his IEP. Cameron's supposed to have a one-to-one. He didn't have a one-to-one. He disrupted the class. And so if the answer to any of these is yes, if you can say yes, Cameron's disruption of class was caused by his disability, or it was related to his disability, or the conduct, his disruption was related to the school's failure to implement his IEP. If the answer to any one of these, not all of them, any one of them is yes, then the school may not change his placement without parental consent, must return him to school, and must do a functional behavioral assessment and a behavior intervention plan. So just wanted to walk through that just a little bit more. So if the school decides that Cameron's disruption of class is a manifestation of his disability, They can't change his placement without parent consent. So they can't move him to an alternative school or anything without the parent's consent. Let's say the MDR happened on the 6th day of that 13-day suspension. Cameron's going to be returned to school on the 7th day. And then the school also has to make plans for the school to do a functional behavioral assessment and a behavior intervention plan. And that is plans and assessments that are designed to address the behavior that happened. So all of these things are what Cameron's entitled to under the Individuals with Disabilities Education Act because he has an IEP. So there's a few other things that I wanted to note here, some tips for parents in an MDR hearing. And so again, please feel free to ask questions if you have anything that is not fully explained or any questions that you have. So one thing that happens in MDR hearings, and that's the second note here, that I hear a lot, unfortunately, from school divisions, is he knew what he was doing. He knew what he was doing is not the standard for an MDR hearing. That's the standard for criminal adult legal cases. That's not the standard for a manifestation determination review hearing. And so it's really important that school divisions not have that as their standard and not list that in their documents. It really needs to be, the questions that we already identified. So that's not the standard. And as parents and caregivers, really push back on that analysis because that's not what schools should be looking at. Also wanted to note that some tips here in terms of things that you can use in a manifestation hearing that are really important. So one is it's really important for in IEPs and individualized education plans for present levels. So when you have an IEP, your child has a disability and they have an IEP, you go through, there's lots of different parts of that plan. And of course, one of them is the present levels, the part of the IEP where you say how the child is doing now and kind of what their different, what their disability is like, what their symptoms are, what their behaviors are, that kind of thing. It's really important in the present levels portion, particularly if you have a child with behavioral needs or somewhere where you can anticipate that that child might get in trouble at school, to really list out all of the symptoms that are caused by that child's disability so that you can pull them out in an MDR hearing. For example, if you have a child who has ADHD, I like to put in the present levels all of the different ways in which a child might be impulsive or make rash decisions. All these types of things might help explain why a child does something later that might get them into trouble. All of the different symptoms that come out, it's important to put them in the present levels portion. It's also important to note too, that, and this part gets a little wonky, so bear with me, but if you have a child who has been found eligible under, say, dyslexia, so say a child has dyslexia, and that's what they've been found eligible for under their IEP, is a specific learning disability. But say also that child has ADHD, but that's not the category they've been found eligible for. You can still bring up ADHD in this manifestation hearing as long as it's noted in the IEP. So if you have that child who has dyslexia and it's just that they have the specific learning disability, you can also make sure to put in the IEP that child has ADHD and bring it up in the hearing. So just an important tip to note, make sure to put all of a child's disabilities in the present levels, make sure to put everything in there. It's an important advocacy tool later in an MDR hearing. Finally, 2 more points on MDRs. If a child has a 504 plan, they are still entitled to a manifestation determination review hearing. They are not entitled to services upon removal unless all children get that, but they are entitled to an MDR hearing. So if your child doesn't have an IEP, they just have a 504 plan, which is another type of plan available for students with disabilities, they are still entitled to an MDR. Now, I want to go back to John really quick. So John, again, is the student who doesn't have an IEP. Remember, we had a couple slides ago, John, who was the student above, who is a 5th grader, who has also been sent to the principal's office for disrupting class. And remember, we talked about how he doesn't have an IEP, even though he has ADHD. So say that John's mom actually had sent a letter to the school on October 1st saying that she believes that John has a disability under special, and he should be entitled to special education services because of his ADHD. And she says, I think he's been disrupting class. He's been, kind of disruptive at home. I think he needs to be evaluated for these services. And then say on October 3rd, John disrupts the class. At that point, I would argue that the school needs to do a manifestation determination review hearing for John as well, even though he hasn't been found eligible for special education, because the school's been put on notice that he has a disability. And so it's important that that MDR is still conducted, even though he doesn't have an IEP. So just an important tip to keep in mind for that as well. So again, I know that was a lot of information on MDRs and lots of tips. If you have any questions, please put them in the chat and we will try to answer those as best as we can. So one of the things that we talked about during the rights that attach for Cameron, remember, so Cameron was the student who disrupted class because, and he has ADHD, and he was found and say he's been suspended for 13 days again, and they go through the manifestation hearing and they find that it's not a manifestation. They say that Cameron disrupted class and it wasn't because of his ADHD. It wasn't because the school didn't, provide him, didn't implement his IEP. Something else was happening with Cameron and it wasn't a manifestation of his disability. So if they conclude that, the school can change the child's placement, so they can send Cameron to an alternative school or send him to homebound or things like that. But the school must still provide Cameron a free and appropriate public education. John is not entitled to this because he doesn't have an IEP, unless some of those exceptions that we talked about are at play. So when we talk about, FAPE during this process and services during removal, these have to start on the 11th day of the removal. So for the first 10 days, they're not entitled to anything necessarily, but services have to start on the 11th day. And they have to allow the student to make progress on their IEP goals and participate in the general curriculum. So both of those things have to happen in order for that child to receive those services during removal, the services that they're entitled to. Just wanted to mention disciplinary alternative education. So we hear about alternative education a lot in our work. Generally, there's no right to ongoing educational services following a suspension or expulsion. So say John, for example, he was suspended for 13 days. There's no right for him to receive any services during that 13 days. He's just at home. There's nothing that the school has to do. However, the school may decide to send John to alternative school, which they can do. The school may also decide to send Cameron to an alternative school if they find it's not a manifestation of his disability when he disrupted class. So these things, can include a lot of different things. The code, you can see the code section identifies several different things. I'm not going to name all of those, but alternative education can look really different across school divisions. Sometimes it's okay. Sometimes it's not what we would hope. And so just wanted to let folks know that is something that happens. And alternative schools do exist in many school divisions across the state. I did want to mention this, though. This is an exciting new law that passed this past session. And so even though schools are not, students are not entitled to services during removal, there is this new law that says that students who receive a short-term suspension, so again, that's 10 days or less, are able to access and complete graded work during and after the suspension. So if you are a parent of a child who receives a suspension for 10 days or less, I would make sure that you know about this law and that you are telling the school that your child is entitled under the law to complete graded work during and after the suspension to make sure that they do not fall behind. And I put the code site in there too, so that you can use that. So I would make sure that you advocate and make sure that they're getting that opportunity while they have that short-term suspension. So now I wanted to mention appeals. So levels of appeal and long-term suspensions and expulsions. So again, there is an appeal process for short-term suspensions. There's a little bit of information on that in one of the following slides. There's a right to appeal. It's not as extensive in terms of the levels of review. There's an endpoint, and each school division kind of does it differently for the shorter term suspensions. So I would make sure to look at your school's code of conduct for that. But for long-term suspensions, there's 2 levels of appeal. There you can appeal. So this is where the principal says, I'm going to suspend a student, and then you can appeal to the superintendents. And this has to be, remember, in the notice that parents receive. All the appeal process and what those rights are in the notice that you receive, that a parent or caregiver receives. So you can appeal to a superintendent within 10 days, and then after, if a school superintendent upholds a suspension, you can appeal to the school board within 30 days. I will note that different school divisions have different appeal deadlines. So I wouldn't just go with this 10 and 30. I would look at the notice and your student's code of conduct. And as Brittany will mention later, respond immediately to all deadlines because some of them are very short. If the school board upholds the suspension, you can then petition for judicial review in circuit court. This is 30, you have to do that within 30 days. And it's a very high standard. And I'll talk about that in a little bit, but this is a pretty high standard and a more complicated appeal for sure. Again, deadlines for appealing could be very short. If you walk away with very little other information from tonight, I think our biggest tip is going to be make sure to look at the notice that you receive about your child's suspension or expulsion, and then make sure to check the code of conduct and respond immediately, because some of these are really very short, much shorter than you can imagine in terms of appeals. So I've seen it as short as 3 days. So just really important to respond immediately. So this is a chart that I put in here just to lay out the information that we've already gone over a little more clearly. Again, I'm going to make sure that Pizzi and Love have this presentation to give out to you all. I won't go over this now, but just wanted you to have another way to view the information and have it laid out in a little bit of a different way. So we haven't talked too much about expulsions during the presentation. Did want to mention a couple of things about expulsions. So decisions to expel a student have to be based on the following factors. So I'm not going to read them all, but there's a lot of different things that a school has to consider before expelling a student. And they have to consider these, as part of the hearing, determining whether to expel a student. So it's important, that parents also consider all of these factors, parents, advocates, and caregivers, and come in ready to advocate based on these factors. And so I want to note too, again, expulsions are for 365 days. There's no right for the student to go to another school within a division when the child is expelled. However, a student can try to go to another school, but there's not necessarily a right for that student to do that. So just wanted to mention that as well. Again, we talked briefly about judicial review of suspensions. I recommend talking with an attorney before doing this. You're welcome to call our office. There's information on the last slide about resources and how to contact us and what cases that we take. It's a really high bar for judicial review of these cases. And so just want to make sure that folks know that, but it is an opportunity for appeal. Finally, just wanted to mention school resource officers in this process. Again, the next session that's going to be taught by Teresa Hepler and Ashley Moore in our office. They are going to be doing a session on school-based arrest, but just want to mention that school resource officers should be advised if your child has an IEP or behavior intervention plan and for what. And I would try to include this in a child's IEP because again, school discipline, even though school resource officers are not supposed to be involved in school discipline matters, we see a lot of blurriness there because school codes of conduct often mirror criminal codes. And so it's just really important that school resource officers be advised when children have disabilities so that they can be aware of it and respond accordingly. So that is all that I have in terms of substantive information, but Brittany is going to share several tips for parents advocating in this process. And so I will turn it over to Brittany.
Thank you, Cassie. I also just wanted to take the time just to share one of the stories that one of the participants put in the chat. So I am a CASA and had one of my kids expelled for what I thought were pretty minor behavior issues in a child who's a 7th grader in the midst of a crisis with a history of a lot of trauma. We appealed and we won, but it was frustrating and scary that it would happen so quickly. It was a 3 strikes and you're out. And I guess that's Louisa County. And I'm just going to double check to see if there's any other stories to be shared. I don't see any additional ones in the chat, but I did just want to thank you for sharing your story. Your courage is appreciated and your sentiment has been heard. I guess the story just reminds you that one of your greatest abilities is to be an advocate for your child, whether you're a CASA or whether you're a parent or what may have you. And Cassie, if you just go to the next slide, I'll talk about some advocacy tips just going forward. So it's just important to note, always, talk to your child just to figure out exactly what transpired that day, just to gain a little bit more clarification as you progress moving forward. Also, ask clarifying questions: who, what, where, when, and why, just so you can have a clear understanding as to what took place that day. And if you would like to, feel free to arrange a school meeting where you can discuss some of the behaviors that happened regarding your child in school. And just, if you would like, you can request school records regarding the incident. So just keep that in mind. Next slide, Cassie. Thank you. Some additional discipline advocacy tips, as Cassie mentioned earlier: respond immediately. So just take note that a lot of these things have deadlines, and you just want to do your due diligence to respond. Just to mention again, understand the dates, the deadlines, and then just the notice requirements. And then also just keep in mind that the more people that can speak to your child's ability, the better. So if your child has maybe a coach or a mentor outside of the school that can just speak to some of their positive qualities, ask them if they wouldn't mind just writing something on your child's behalf. I'm sorry, next slide, Cassie. And we also just wanted to provide just some general advocacy tips. Always put everything in writing. So that way, if time passes, you can refer back to it. Make sure you do your own research. Cassie's provided some of the codes for Virginia, but there are just some additional resources on the LAJC website that you can turn to. And just a few other tips: just encourage your child's strengths. Keep a file with all education documents for each child. And just as I mentioned before, it's important to include the child. They were the ones who were in the midst of the discipline. So I think it's also rewarding to have them be a part of it as well. Thank you. And just as mentioned, if you would like more information, Cassie mentioned there is a Helping You, Help Your Child. I think it's called just like an informative, like, oh goodness gracious, my mind, manual on the website, LAJC's website, that you can check out. And then if you have any additional questions, please feel free to use the contact and information on their website just to reach out. And then also the Virginia Model Code of Conduct has a number of the codes that were mentioned previously in the presentation, just for your reference. And I will turn it back to Cassie for some of the questions that are in the chat. Thank you.
Thank you so much, Brittany, and thank you so much for being here. So that concludes our presentation, everyone. We do have a survey that we would love your feedback on. We always want to see how we can improve the presentations that we do and the information that we provide to make it as informative and useful and helpful as possible. And so we'll make sure to pass that along to Love. I can also put it in the chat if we can do that. And so I will. I'm now open it up to questions. Thank you so much for being here and for listening.